Take it off your head now. Remove your face mask so I can identify you. I need to see your entire face. I can't see your face.
Ma'am,
I can take her into custody. I don't have time for this. You'll have a bigger issue sitting down in jail.
how long am I?
Oh, no, you didn't. No, you didn't. I cannot see your face. And I'm not going to go back and forth.
Welcome to an explosive courtroom showdown. A defendant refuses to remove her face coverings, citing bizarre health reasons. The judge threatens contempt. The prosecution missed critical deadlines. Jury instructions weren't submitted on time. This case spirals from a simple hearing into absolute chaos. Let's dive into this jaw-dropping confrontation.
25-02183. Appearance, please.
Jeffrey Billabay on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Savage. Is entering the courtroom now.
But am I having an out-of-body experience, Mr. Raleigh? Have you met with your client today?
I have, Your Honor.
Have you talked to your client about how to appear appropriately in court?
Your Honor, she didn't say health concerns.
What does that got to do with a hoodie and a hat on her head? In the middle of my courtroom. Are your witnesses here?
Yes, Your Honor.
You're having a trial today, correct?
We have pitched an offer, so we were just waiting to hear.
We don't do offers on the day of trial in my courtroom. That's been my policy, and the attorneys here and my staff are very much aware. We had a final pretrial on the 22nd of September, to which your office represented that the victim was here.
Correct, Your Honor.
And so if there was no offer extended at that time, the time to negotiate is now over. Today is the date and time set for trial. Are we running a trial or no? Or is she pleading to the charge?
She's, I would leave that to defense.
She's not pleading to the charge, Your Honor.
Okay, you can call on the jury.
Thank you, Your Honor.
I don't have jury instructions. They were supposed to be to us by Friday, 3 p.m.
That is correct, Your Honor. I couldn't reach the victim. I tried to contact her on Friday. She did not pick up the phone. I left a message. So we showed up today thinking she wasn't going to be able to show up simply because I couldn't consult her or give her any offers prior to this date, Your Honor.
You had a final pretrial. You
Correct.
said that the victim appeared.
Yes, at the final pretrial, the victim did appear, Your Honor.
Well, what does that got to do with my jury instructions that were supposed to be to me by Friday?
The judge is rightfully frustrated. No last-minute deals on trial day. That's the policy. The prosecution had their chance at the pretrial but failed to negotiate then.
I apologize, Your Honor.
Where's your jury instructions, Mr. Raleigh?
I have them prepared. I can forward them to the court, Your Honor.
I need them within the next 20 minutes.
Yes, Your Honor.
And I don't know when you're going to do it because we're running the rest of this docket right now.
Yes, Your Honor.
Your client can go figure out how she can be appropriately. You need to take your hood and your hat off now. You can't dress like that in court. Ma'am. I'm sorry? I can't even identify who this person is. Her entire face is covered, Mr. Raleigh.
Yes, Your Honor.
Take your hood and hat off so I can identify you. And whatever's on your head, take it off.
I've already made it.
You have one choice: to do what I say, or you be held in contempt. You still have things on your head. I can't even see your face.
Ma'am, I would like to protect my.
You can remand her into custody.
That's the only reason why I'm asking you. I've already made it clear on multiple accounts that I have vaginal problems, and I'm also health concerned because.
What does that got to do with? I have to be able to see your face. What does that have to do with that? I can't see your face. I'm not going to go back and forth. I'm not going to negotiate. There's rules and there's policies. If you can't follow them, you'll be held in contempt and you'll be remanded into custody. You can remove the items or you can be remanded into custody. It's your choice.
How long are we discussing?
Until I can have the contempt hearing. Because you're not going to sit in a trial like that either.
But I don't want to take my mask off in front of other people.
Take your hat. Whatever's on your head needs to come off. You don't wear do-rags in court. Take it off your head now. Remove your face mask so I can identify you. I need to see your entire face. I can't see your face.
Ma'am,
I can take her into custody. I don't have time for this. You'll have a bigger issue sitting down in jail.
how long am I? Yeah, I've already taken the mask off.
Oh, no, you didn't. No, you didn't. I cannot see your face. And I'm not gonna go back and forth. Thank you. You remove it down lower so that I can identify you. When I said I've identified you, then I will allow you to put your mask back on. Not only that, you look at me when I'm talking. There's going to be a portion during this trial where you need to be identified. You'll be ordered to remove your mask again then. Your attorney should have told you that. You can have a seat out there and wait until it's time for us to call you in for jury selection. Mr. Raleigh, you need to talk to your client because my patience is very short already with her.
Yes, ma'am.
You understand?
I understand.
Okay.
With the Rodriguez matter,
Back on the record in the matters of the state of Michigan versus Juan Rodriguez Reyes, 25-02843 and 44.
Jeffrey,
Well, your appearance is already on the record. I
Thank
just
you.
don't know how we're proceeding at this time.
yes, Your Honor, I have had an opportunity to look at the evidence that defendant has shown me on his phone. And as an officer of court, I can make representation that defendant is now in compliance. And so in the interest of justice, the people would move to dismiss this case.
Both on citations, they're dismissed. You're all set.
Thank you, ma'am.
Thank you. We're back on the record in the matter of the people of the state of Michigan versus Portia Savage, 25-02183.
Jeffrey Billabill on behalf of the people, Your Honor. I know my appearance is probably already on the record.
All right, I think she went downstairs momentarily, but her bag is still here, so she'll be back soon.
Wait, she mentioned vaginal problems to justify wearing a hood? The judge needs to see her face, not anything else. This is basic courtroom identification protocol.
No,
That's right. It's a dog at large. I sent pictures, and he's talking for last week about the issue, the relationship. So control on scene that they gave her a new time on which she did that and she's fixed up with them and some pictures of it.
What's the name again?
Hughey, Hughey.
H-U-G.
Oh, she was supposed to get a cat before she was released. Did she get
First name is Kira.
Savage?
You sent me an email?
Yeah, I'm Friday.
I don't even know.
Security said she did go downstairs.
I don't think she'll leave it there. So,
It's a backpack.
I don't have an email.
it's more of a tote bag.
Walmart.
An Aldi's tote bag.
Looks like something you would get it.
We don't even know what's in this tote bag.
Looks like clothes, some personal items.
But she's so concerned about her health, wellness. Why would she leave her bag unattended? What's up, Nespero? They're a nurse. Where's the victim?
She's outside, Your Honor.
She's in the courtroom.
Oh,
Oh.
sorry. I apologize.
Today? March, well, done with that, so if I can show the date or something, you know. Yeah, well, let me make sure it's the other, yeah, I might say the wrong thing. Let me just do one second. So that's no, it's right under.
Girl can come back. No. Hi, girl. Great. Just shrimp body.
After all that drama, she finally complied partially. But then she left voluntarily while her bag stayed behind. Where did she go? Is she coming back?
Ma'am, what is your problem? Ma'am, what is the problem? I can't even hear you. I cannot hear you. I cannot hear you.
I'm not trying to be disrespectful.
No, then don't be disrespectful. You don't run my courtroom, I run it. You're gonna come in here, I'm gonna go on the record properly, and you're gonna present yourself appropriately. And not with a rag hanging off your head.
This is actually all that I have right now.
But you can take it off your head. I'm not asking you to remove your mask. I've identified you. You can keep the mask on. Okay, back on the record.
Jeffrey Billaby on behalf of the people, Your Honor.
Jacob Riley, on behalf of Ms. Savage.
Today was the date that was scheduled on my docket to hold a jury trial. The attorneys were both advised of the policy in this court. It's the 54A district court policy, which is we need to be notified by 3 p.m. on Friday whether or not a jury is going to be called in. And there's a reason for that policy. Mr. Billaby, you asked me if I could extend the policy on Friday. I told you no, because it's not even my policy. It's the court's policy.
That is correct, Your Honor.
And so our staff did not get anything from either attorneys, one way or the other, indicating whether or not there was going to be a jury trial. Therefore, that information was not properly provided to administration, and they call in a jury on Friday. They don't call it in on Monday morning.
Yes, Your Honor.
And so we brought a witness in here for no reason, because we can't call a jury in. And that's because of the attorney's failure and not the court.
I understand.
And I want to make that very clear.
Round 2. The judge asserts his authority. You don't run my courtroom, I run it. He'll allow the mask but demands proper courtroom decorum and respect.
Was there an offer that you intended to extend today?
Yes, Your Honor. In consultation with the victim and my unit chief, we extended an offer of disorderly. and I understand that is not what the court's policy is. Before I get to that, Your Honor, I just want to sincerely apologize
Ma'am,
for putting.
wait a minute, ma'am. Take that off your face. Excuse me?
I'm saying I'm very sorry. I just don't feel well at all.
I can recognize that, but you can't cover up your face while you're standing in court. I'll allow you to cover your mouth and your nose for your health, but you're not going to cover your entire face, okay? Okay.
Your Honor, I just want to sincerely say I sincerely apologize for mishandling this matter, and I understand that puts the court in a very difficult position because now we're having to call a jury. I did attempt to reach out to the victim on Friday. She informed me that she tried to reach back to me. I didn't get that. And obviously, I wasn't anticipating there would be a jury trial here today. Either way, Your Honor, I accept my failure to be able to promptly inform the court timely whether this to set a jury trial. And it's a policy that the court has made very clear to me. And so I want to apologize on that, Your Honor. The offer in this case, I had a discussion. I talked to the victim and in consultation with my unit chief. Today, we offered a disorderly person. This offer is agreeable to the victim and to the unit chief. And that's what we offered here today, Your Honor. And this is the first time I've had really any opportunity to consult with the victim during the entire duration of this case. This was my first time seeing her and even talking to her in person, Your Honor.
Did the victim appear on September 22nd?
Yes, Your Honor, but that was with a different prosecutor. She appeared on the final pretrial, and she did indicate that the case will be set for jury trial according to our notes, Your Honor.
Correct. Negotiations in my courtroom happened prior to. And so if the victim appeared on the 22nd, whether it was you, Mr. Bilibay, or someone in your stead, because I recognize it's not your fault that you just got subbed into this courtroom, but you put the court in a position, your office that is, when you keep changing the attorneys, there's no consistency going on. Whoever is here should have extended an offer if an offer was viable at the time. If there could have been an offer extended, it should have happened then. That's the point of the final pretrial, okay?
That is correct, Your Honor.
And so that's a message you can take back to your staff or to your office so that they know, I don't care who is in this courtroom. If the victim is here for final pretrial, what do you think we're all coming here for? A kumbaya moment? It's to try to work out the matter and see if we need to go to trial. Once I set a trial date, it requires all of us to be here. And it requires people to move their work schedule. You didn't think the victim had someplace she needed to be today?
She did, Your Honor.
I have personal things going on that I had to rearrange so that I could be here in person so that no trials were being reset, only to get here and not to have a trial. Ma'am, are you okay?
The prosecution offers disorderly person a major reduction, but they keep changing attorneys with zero consistency. This prosecutor never even spoke to the victim before today.
Okay. And so, Mr. Raleigh, there's an offer of disorderly person. And then, Mr. Bilby, I accept your apology. And I recognize that part of this is not your issue. It was a change in prosecutor office. Nonetheless, is she going to accept the offer?
You either accept the offer today and it's accepted as a plea.
If you need more time to talk to her, I could give you time to do that.
Or we set it for if we can have a moment, Your Honor.
No problem. Off the record.
Thank you, Your Honor.
After all that chaos, she accepts the plea deal. This case showed massive failures, poor preparation, missed deadlines, and disrespectful courtroom behavior. If you found this shocking, hit that like button, drop your thoughts below, and subscribe for more incredible courtroom breakdowns.